Hello and welcome back to the 10,000 Startups podcast. This is Roger Royce. I'm a partner with Haynes and Boone in Palo Alto, where I do emerging growth and venture capital. And each week we bring to you original content on legal issues of interest to startup companies. And today we have a guest to talk with us about something that if you're looking for an exit, and if you do an exit, you are going to run into this, you're probably going to run into this issue. So forewarned, forearmed, all of that. And the topic of this week's podcast is called the earnout litigation trap. And that term litigation trap, I picked it up from an article in the legal press this week, and it was coined by our guest, Haynes and Boone partner, Zachary Jacobs. Zachary is a partner. He does M&A in our New York office, and M&A, private equity firms, portfolio companies, public companies, private companies, M&A dispositions, investments, joint ventures, and strategics, and a variety of different industries that span healthcare, chemicals, manufacturing, technology, etc. So, Zachary, thank you for being with us today to talk about earnouts.
Yeah, good to be on.
So let's start I guess for our audience, let's level set. What is it? What is an earnout, and why would somebody want one in their deal?
Right. So, in an M&A context, ideal world is a seller, you're getting all your cash at closing and you ride off into the sunset. An earnout is essentially a mechanism where part of the purchase price can be deferred to a post-closing period. So then you get into the question of, well, what's the trigger for payment? And that can take some different forms. One can just be the passage of time. That would typically be with a smaller acquirer doesn't necessarily have the money to pay everything up front. And so it's essentially, just within 12 on the anniversary, the next installment comes due. But more common would be performance based. And for there, the driver is really, the achievement of certain milestones, whether it's hitting regulatory hurdles or sales milestones or some combination of that. And the reason why I mentioned regulatory is you do often see this in highly regulated industries, biotech, pharma, where there's a really promising product. And if it gets FDA approval, it's going to be a home run and make billions of dollars. But it's also possible that it never gets past phase two with the FDA and it's worth zero. So in that kind of situation where there's this potential unknown, the earnout provides a way for buyer and seller to sort of share that risk to give, the buyer isn't going to put all this money up front if the product never goes anywhere, but the seller also doesn't want to give up all that potential upside. So the earnout is a way to say, if, once FDA approval is obtained, once you make your first sale, once you hit X million dollars of revenue, then additional payments will be payable by the seller, by the buyer to the seller. And so it's a way to get additional purchase price post closing.
Okay. So let's say, just in another way of saying it, we have a seller and a buyer, and they can't agree on what the value of the company is. So we'll say, look, how about you give me X dollars today, and then give me Y dollars in the future based on the performance of the company, and that'll bridge that valuation gap. Why do you call it a litigation trap? Seems pretty straightforward the way you described it.
Right. Well, so you get into I guess the most hotly debated items are really, those triggers themselves. So you'll get a lot, sometimes you'll see accounting disputes. And that's why, when you're drafting the whatever it is, the purchase agreement or transaction agreement for this deal, you really want to be specific about the way that you're going to measure the achievement of these milestones. If it's revenue based, probably pretty easy. If it's EBITDA based, the achievement of certain EBITDA milestones, then you need to get pretty granular about what are the add backs and what are the accounting methodologies we're going to use to calculate this. So the best way to avoid these future disputes is to be as granular as possible in the documents themselves. So it's very clear how it's supposed to be calculated. Um,
Well,
yeah,
even if you're really granular, the buyer has to support the business, right? To hit these targets.
that's right.
So
That's
it
right.
feels a little like you're asking the fox to guard the henhouse here.
Well, yeah, so that and that's really the second area where you see a lot of disputes. It gets into the efforts that the buyer is going to use to achieve these milestones. And as you say, there's a bit of a buyer might argue, well, our interests are aligned. I'm buying this business and I'm paying all this money. Of course, I want it to succeed, and if I succeed, then you succeed because I have to pay you more. But there certainly is more to it than that potentially, because a buyer might find another target that it thinks is even more impressive and decide, post closing to move on to focus its attention on different a different product. So you if the earnout is contingent on achieving some R&D milestone, then as a seller, you want to have some sense of the effort that the buyer is going to put into that R&D. And so there's often, around the on at the negotiating side, there's a lot of discussion about what level of efforts the buyer has to put in, what they can and can't do. Certainly, as you say, you want to avoid the buyer really playing games and, diverting revenue to some other subsidiary so that it wouldn't be caught up in the definition. You don't want that sort of bad faith action, but you also don't want a buyer to combine your product line with some other product line in a way that screws up the calculus. So that's where you see litigations, and it's where you see the Delaware courts increasingly insinuate themselves and try to make their own determination about what's fair for the parties.
Yeah, so I'm almost always on the sell side. And the way that you described that, it feels like you can't possibly anticipate all the different ways that people could manipulate these formulas, especially if it's a complicated combination of revenue, EBITDA, and maybe some research milestone. So let's start from the sell side first. What can a seller do to protect themselves on this? What kind of language would they have in their agreement?
Well, certainly you want as much control as possible. So one thing to consider is are the founders, or in our case, I know your audience is a lot of the startup community. Are they going to continue with the company post closing as an employee? If not as an employee, can they get a board seat, some way to have eyes, boots on the ground, as it were, and to be able to control to the extent possible the outcome. And also, even if you're not going to continue with the company, having a sense of what the buyer's plans are for the business, to understand their projections, to understand their business thesis, in order to get peace of mind that there's some possibility of hitting this.
Yeah. Now let's flip it around and you're on the buy side and your perspective is completely different. You're thinking, well, I shouldn't have to hang on to a loser, right? If if this rock doesn't float, I should be able to cut it loose. How do I protect myself from having to fund something forever that it doesn't make commercial business sense to do so?
Right. And so when you do, at the extreme, and I have seen this where it basically says, short of the only buyer obligation is basically, I won't do anything on purpose, essentially in bad faith, to try to avoid paying this earnout. But beyond that, I'm free to, I'm paying a lot of money up front. I'm free to operate this as I wish. Um, and then you get on the sort of sliding scale that you can add additional obligations of the buyer, and especially with some of these growth stage companies where they need to where they need to achieve some regulatory hurdle, or you often see a commercially reasonable efforts
Mm.
standard. And now with especially with these recent court cases where courts are coming in and opining as to what commercially reasonable efforts means, you're seeing a lot more drafting in the agreement, basically with a definition about what it means. And so, from a buyer perspective, back to your question, what is it the efforts that a hypothetical company in the industry would use for this product? Or can it be inward facing such that the buyer is able to take into account buyer specific considerations that a hypothetical company may not have to consider. So
Yeah.
yeah, as a buyer, you really want to have as much flexibility as possible.
Yeah, no, that's really interesting. The commercially reasonable efforts, and the article I said it that you were quoted in, that they talk about that kind of like that's where the rubber's hitting the road on this issue, the efforts clauses. And what kind of jumped out at me is they quoted the judge saying, and I've been there too, where I've argued forever over, is it best efforts, is it reasonable less efforts, is it commercially reasonable? And here's a judge that says, for the most part, we view the effort standards as exactly the same,
Right.
which tells me that we're going to have to put a fair amount of definition into what we mean by that. Is that where the market's going on this for lawyers?
Yes, absolutely. Yeah. And yeah, and even listing all the various it'll say commercially reasonable efforts taking into account XYZ, and it'll list all these sort of considerations and factors that the buyer is allowed to take into account, the regulatory environment, broader macroeconomic situation, profitability. And that gets to again some of the questions, if especially if a buyer has other product lines. If times get tight and their other project lines have better margins, for instance, are they allowed to sort of focus their efforts on these other product lines that are more profitable and not focus as much on the business that was just acquired, in which case the earnout might suffer. So that is where you see a lot of these disputes. Another interesting area I've seen is if the seller does have rollover equity, so they have a continued equity interest in the post-closing business. I've seen fiduciary duty claims as well. If the allegation is that the board of the buyer has breached some fiduciary duty by pursuing one business avenue over this one that would have hit the earnout. So that's another thing to consider. Are you going to have that type of exposure as a buyer, or potential leverage as a seller if you're going to continue to be an owner of the business?
Yeah, that's an issue that just kind of is throughout all of corporate structure. And I'm constantly trying to avoid having minority shareholders in any one
Right.
company when you've got different businesses and other companies. So
Right.
I can totally see that one arising. But let me ask you this, Zach. Based on this recent flurry of cases that you commented on in the article and what's going on in the industry in the market, is there now a market standard for where we're all settling? Because, a lot of times there's a lot of flurry of activity and we all kind of settle on a standard that's the mid ground that we all accept and move on. Or is it still just heavily negotiated and highly factual?
I think it's the latter. I sort of break these into two buckets. One is the one that you mentioned where there's a true valuation gap. I'm sort of an established company and these are my projections, and I think my company's worth X, and the buyer thinks it's worth 90% of that. And so it's really I wouldn't take the 90%. And the earnout is a way to sort of, if I'm confident in how this is going to perform post closing. It's going to get hit. I'm gonna earn the earnout, and I'll get the full purchase price that I expected. In that case, where it's only a smaller portion of the purchase price, I actually see fewer buyer obligations, or because the buyer just sort of has to keep operating as in the ordinary course, from my perspective as seller, in order to hit this. Where you see a lot more meat on the bones from a drafting perspective is where you have one of these biotech deals where half the purchase price is in earnout, and then you really do see a lot more. I wouldn't say handcuffs on the buyer, but there's a strict regime in place for how they're allowed to conduct themselves.
Yeah, so what I tell my clients on deals is if you're on the sell side, don't expect to get your earn out. Just pretend you're
Exactly.
selling this company, and all you're getting is the cash and
It's
the
the uh,
front.
it's the cherry on the ice cream on the sundae, not the ice cream.
Yeah, exactly. That'll get a better valuation than you might have gotten, but don't count on it. Don't Shouldn't be your
Yes.
retirement. And if you're on the buy side, just expect that you're going to end up having to pay it when you price the deal. So whether you're on the buy or the sell, you should view it as either a never earned or always paid.
Right. Right.
And these days, in the market, we got this baby boomer thing where we're in our closely held practice, not so much the startups that are up and out within a few years, but our closely held practice, you know, baby boomer founded companies have been operating them for 40 years, and now they're time to exit. And of course, they don't want to stick around. But what you said, the very first point you made, is one of the best things a person can do is just stay with the company during a transitional period to make sure, or to at least do what you can to help make sure that the company hits those earnout targets. Any
Right.
other advice for sellers or buyers in this?
Well, certainly, I mean, there are other factors that can be at play here, in how it's structured. One is whether it's a cliff or a sliding scale. So, if I don't hit the EBITDA target, can I get some percentage of the earnout, or is it all or nothing? If I fall short, I get zero. And then another factor that you see in structuring these is there a cap? In no event can you earn more than a certain amount, or is it uncapped where you get 10% of all revenue in the first 12 months, up to infinity? Another question is, are there clawbacks if these earnout periods last for several years and you can earn a bit each year? What if you knock it out of the park in the first 12 months, but then the second year things don't go so well? Can they claw back some of the earnout they paid you for the first year or not? Typically, that is not possible. But there's also an interplay. The earnout is it, they have the buyer has some of your money as seller, basically. So a lot of these M&A deals, there'll be indemnification regimes if any of my representations and warranties aren't true. And the earnout is basically a pot of cash that the buyer can set off against if you owe them anything for some other reason. So the
Mm,
earnout, it's interesting. It's almost like an escrow or something, a way that they can, a way that you can satisfy these indemnification obligations. Um,
yeah,
and I
I
think,
like that.
another thing maybe founders should consider is taxation. Um, the good thing about these earnouts is, if they are purely performance based, they'll be taxed as, get capital gains treatment as purchase price. But one pitfall to look out for is if there is any continued employment condition to, as a founder, you have to still be with the post-closing company in order to earn it. If that condition is in there, it's going to be ordinary income, treated as, compensation. So that's something to look out for, and get your tax
Yeah.
planning ahead of time.
Absolutely. Another pitfall that I've come across, I don't know if we worry about this as much as we used to, but it's just securities laws. because the earnout looks a lot like a security, doesn't it?
Mhm.
I mean, it meets the definition. Uh,
Right. And so, you see a lot of language making clear that it's not transferable, for instance.
hmm.
So yeah, in order to try to alleviate some of that. But yes, absolutely. That's been something to consider on the legal side for sure.
Complicated stuff, but I like to tell clients that the result that you get is going to depend on how much complexity you're willing to live with. And this is one of those cases where if we are careful about it, we can get a really good result. If we're not careful, then we've got that litigation trap that
That's
you
right.
mentioned. And once you've litigated, you've already lost. That's what us corporate lawyers say. If you're paying litigators, it's not going to be good for anybody.
Yeah, and lawyers, we do our best to try to guard against that and avoid that. At least as transactional lawyers, I don't want anything I touch to ever go to litigation. But there's at the end of the day, the founders, the sellers and buyers also have to have a mutual trust. As a seller, you are giving up a lot of that power and authority and ability to control your own destiny. So you really have to develop a trust with the buyer, have a shared vision, believe in their investment thesis and their ability to carry this business forward.
Yeah, that's a really good point, and it's one that sometimes gets lost, especially here in the United States. But all the paper in the world is not going to protect you from having a result you're not super happy with. I mean, the trust part is really important. Just know who you're doing business with. And if you're on the sell side, you should diligence your buyer and make sure that there's somebody that doesn't have a track record of fighting with every company they acquire. And if you're on the buy side, similarly, you want to know you're dealing with people that you're going to have to get along with.
Yeah, I'm sure we've all had a client that decides to take a lower offer just because it's going to be
Yep.
smoother sailing.
Yep. Okay, well, I want to thank you, Zach, for being here and talking with us about the earnout litigation trap and how we can plan around that and turn it into a good result rather than an unhappy one. This has been Roger Royce with the 10,000 Startups podcast, talking with Zachary Jacobs, a partner at Haynes Boone on earnouts. And we'll see you all next week.